Welcome to the Demidchik Law Firm YouTube channel.
Hello, this is Anna Demidchik, Demidchik Law Firm, and with me today is my colleague Shuyoung Xie, or Lori, as she's known in the English-speaking world. Lori is an experienced family and civil litigation attorney. Today's topic is on a civil litigation matter that she encounters quite frequently in her practice. Hi, Lori.
Hi, Anna. How are you?
I'm well, thank you. Thank you for joining me today.
You're very welcome. My pleasure.
So, corporate defamation. Tell us about it.
So most people would think defamation as saying or writing something that unfairly damage an individual's reputation. But actually, business defamation is also a common occurrence that can have real life consequences for companies, especially in this digital age. As we all know, bad news travel fast and can sink a company in less than a day. So if someone makes false statement to discredit a business, New York law actually gives the companies the right to seek financial compensation in a business defamation claim. Basically, the New York common law uniformly recognizes that a business can be defamed. And there are two types of defamation. One is called slander, and the other one is called libel. So slander means saying something defamatory, while libel means writing or publishing something defamatory. So for example, if a false statement is made in writing through a publication or an internet forum, this is known as libel. And if the false statement is made verbally through a public speech or like a YouTube video, it's called slander. Yeah, and it's also possible to defame a company in two different ways. So, for example, the first common type of slander or libel is to say something false about the company itself. And the other type is to slander or libel the business owner, their top executives, or an important, or what we call key employees. So, of course, each of these can have bad repercussions for the company. And sometimes a company has to take actions to stop that or seek damages, as you know. In real life, if a company or its owners, executives, or key employees believe they are defamed by other person or entities and want to sue such person or entity, they need to talk to lawyers to see whether they would be able to bring a lawsuit.
Why would they be unable to bring a lawsuit? Are there any circumstances when a lawsuit is not possible?
Yeah, that's a good question. Actually, as a plaintiff, you have to prove your case, right? In New York, for corporate defamation cases, there's different court views as to the impact of the First Amendment on the cause of action. So basically, there is little uniformity among the courts as to the elements of a commercial defamation cause of action. But generally, there are four elements that used by most of the courts, not all of them, most of the courts. The first one is the alleged defamatory statements must concern the business, for example, honesty, competence, or efficiency, or it imputes fraud. Second element is the alleged defamatory statement is false or imply a fact that is false and understood to be defamatory. So what does that mean? That means there must be a reasonable basis for drawing the conclusion that the statement is defamatory of the business. If no reasonable person could draw the conclusion that this is something false, then it doesn't meet the second element. So you have to prove that. That's a very common obstacle in the real life. The third element, of course, is publication. So alleged defamatory statements must be published before you can bring such a cause of action. Any private conversations, that doesn't count. The fourth common element is what we call culpability. So, for example, the alleged defamatory statement was made with, at least we would say, negligence. It's a legal term, but some courts requires more than negligence, such as malice.
Higher standard, right?
Yeah, it's
which is basically that it was done on purpose.
Yeah, that's correct. Very high standard. Some cases may fail for the last element. They cannot prove, the intent at the time of committing such defamatory statements. The last thing is jurisdictions are not in agreement as to what must be proved to be able to obtain damages. For example, some courts will allow jury to award damages without proof of injury, or damages, but most courts do not. So you have to prove your damages.
When it comes to jurisdiction, it's really important where the defendant is or where the acts took place, right? Mm-hmm. Okay. So in your experience, what are the biggest problems in proving defamation? Is it absence of some kind of written documents confirming intent, or is it that the damages are really difficult to calculate? What are the most frequent problems that you encounter in this kind of cases?
I would say calculation damages, because you have to give the court numbers. How are you going to prove that? How many, customers, clients you lost because of the defamatory statements? It's hard to estimate. And you cannot just say that I lost customers. The court would want to know how many customers, like orders, how much each order, how many potential clients you lost. It's just cannot be easily calculated. Maybe you have to get some, outside expert to give you an expert opinion as to the estimated loss that you suffered because of such conduct.
And also possibly the businesses should be paying attention to tracking, right? Tracking the leads, tracking customers, tracking who comes to their website, conversion rates from before the defamation, after the defamation. So maybe today, in today's environment with a lot of digital tools, it may actually be slightly easier than it used to be just a few years ago. What do you think?
Yeah, that's correct.
So practically, it might actually be somewhat easier to prove commercial defamation. Yeah. What would be your advice for businesses who are dealing with this problem?
Yeah, if you, first of all, I would say the public relations department of the company to pay attention to those bad reviews. Wherever it shows up, like Google review, Yelp, or any other little red book, WeChat group, all such posting, you have to pay attention to that. And once you notice there's something false or something really defamatory that may harm the reputation of your firm or your company, talk to your lawyer. We can always help you to find out a way to resolve this issue.
Right, because not everything needs to go straight to litigation, right? There are things we can do prior to it actually goes to court.
Yes, for example, we can do a cease and desist letter to see whether the person who posted such posting to take down the posting. That's the way that we call, settlement discussions. We can discuss them in private without, bringing the case in court, because litigation is very expensive. But in other situations, the person, they just ignore the attorney letters, cease and desist letter, whatever they refuse to listen to, the correct voice, then the company has no choice but to bring a lawsuit against them to seek, the damage.
Right, exactly. Anything else that you want to add?
I believe that's it.
Well, thank you so much, Lori. Thank you for sharing your experience and advice.
You're welcome.